You know, sometimes the most dangerous thing a powerful person can do isn't fire a weapon, or sign an order, or call a press conference. Sometimes the most dangerous thing they can do is walk quietly into a courthouse carrying a sealed envelope. That is what happened this morning. And by the time that envelope landed on a clerk's desk, Donald Trump's closest advisors were already using a word in private they haven't used in a long time. One word: jail. Not about a political opponent, not about a protester, about Pam Bondi, the woman Trump himself put in charge of the entire United States Department of Justice. Let that land for a second. The President of the United States is reportedly discussing whether his own former Attorney General should be put in prison. And the reason he's discussing it is because she just handed federal prosecutors what may be the single most explosive piece of evidence in the entire obstruction case against him, an 11-minute audio recording made at Mar-a-Lago, featuring Melania Trump, placed directly into federal court this morning by Bondi's own personal attorney. This isn't a leak. This isn't a rumor. This is a sealed filing logged into the federal evidence system, now sitting in the hands of a federal judge. And what happens over the next 72 hours will determine whether that recording becomes the centerpiece of a sealed court hearing on Monday, or whether Trump's lawyers manage to bury it in procedural appeals that stretch this fight well into summer. I'm going to walk you through every single piece of this, because the details here are not noise. The details are everything. Let's start with who Pam Bondi actually is, because this isn't some low-level bureaucrat going rogue. This is a woman who ran Florida as its Attorney General for 8 years. Trump appointed her to lead the entire Justice Department. She was confirmed. She sat at the top of the most powerful law enforcement institution in the world. She had access to everything, every classified memo, every internal compliance review, every document the DOJ was either releasing or not releasing in the course of this investigation. And she kept something. Reports from yesterday, just yesterday, indicated she had been quietly working with the special counsel's office for 3 full weeks, not publicly, not through any official announcement. Behind the scenes, she was handing over internal DOJ memos she had access to during her time running the department. People familiar with the situation said it looked like either a defensive maneuver or the early stages of something much larger. 19 hours later, she delivered the tape. That is not a defensive maneuver. That is a complete and total realignment. Her status just shifted from potential witness to the central cooperating figure in this entire investigation. And Trump's team has gone from privately frustrated to publicly threatening criminal referrals against her. Think about what that means. The administration is now threatening legal action against the very person they trusted to run the Justice Department. That is the level of rupture we are looking at today. Now let's talk about the recording itself, because this is where the legal stakes become almost impossible to overstate. The filing describes an 11-minute audio captured during a private dinner at Mar-a-Lago in March of 2023. The people at that dinner included Melania Trump. And according to the filing, what Melania said during that dinner goes directly to the heart of the obstruction and document handling charges currently facing her husband. That is not a peripheral detail. That is not background noise from a passing conversation. Statements that go directly to the heart of the obstruction charges. Meaning what was said at that dinner may help prosecutors establish what Trump knew when he knew it, and what decisions were made about the handling of classified materials. Now here is what makes this legally bulletproof for prosecutors and legally catastrophic for Trump. Bondi didn't steal this recording. She didn't hack anyone. She didn't obtain it through some back channel. She accessed it during her tenure overseeing the DOJ's document compliance review using her own official authorization codes. The chain of custody runs directly through her lawful authority as the sitting Attorney General of the United States. That means Trump's team cannot argue the material was improperly obtained. They cannot claim rogue agents collected it without authorization. The most powerful legal argument in their toolkit, that the evidence was tainted at the source, is gone before they can even make it. What's left? Their options narrow to one path. Attack Bondi's personal credibility. Try to convince a federal judge that a former United States Attorney General who lawfully accessed these materials through official channels cannot be trusted. That is a very steep hill to climb, and they know it. Now, I want to walk you through how this day actually unfolded, because the precision of these hours tells you something crucial. It tells you exactly how high the pressure is inside both the courthouse and the White House right now. At 8:14 this morning, Bondi's personal attorney, not a Justice Department liaison, not anyone operating through official government channels, walked into the federal courthouse carrying that sealed envelope. Her own private lawyer, that choice is deliberate. It signals from the first step that this was Bondi acting as an individual, protecting her own position, not the government acting institutionally. By 9:02, the envelope was logged into the clerk's evidence system. At 9:47, just 45 minutes later, Judge Hernandez issued an immediate gag order covering every single party connected to the filing. Every party, documented in the federal docket, confirmed by court officers present in the building. A judge who moves that fast is a judge who understands the gravity of what just landed on his desk. By 10:23, Trump's lead attorney had filed an emergency motion challenging the tape's admissibility. At 11:34, 1 hour and 47 minutes after that envelope hit the clerk's desk, the White House released a formal public statement. They called Bondi's actions an unprecedented act of political betrayal and prosecutorial misconduct. 1 hour and 47 minutes. That kind of speed means someone inside that courthouse tipped off the White House before the docket had even publicly updated. By 1:58 in the afternoon, Trump's legal team had submitted a full package of emergency motions, spousal privilege claim, challenge to Bondi's standing, request for an emergency stay on Monday's sealed hearing. All of it filed in a matter of hours. And at 3:44, something neither side apparently anticipated happened. Melania Trump's independently retained attorney, someone she hired 6 weeks ago, long before today, filed a statement asserting that his client never consented to the recording, never authorized its release, and is claiming spousal privilege on her own behalf. Not through Trump's lawyers, not as an extension of her husband's defense, as an independent legal actor asserting her own constitutional rights. 3 colliding strategies, all detonating inside a single courthouse on a single Friday. And a federal judge now has to sort it out by Sunday evening. Let me translate what Trump's legal team filed this afternoon, because the language is bureaucratic, but the strategy underneath it is very clear. Spousal privilege is a legal principle that prevents a spouse from being forced to testify against the other. Trump's lawyers are arguing that the recording of Melania is shielded by that privilege and cannot be admitted into evidence without her explicit written consent. That is the first motion. The second motion challenges whether Bondi even has the legal standing to do what she did. They're claiming her immunity agreement, the deal she struck with the special counsel's office to protect herself from prosecution in exchange for cooperation, was obtained under false pretenses, meaning they're arguing she lied to get protected status, which would void the whole arrangement. The third motion asks for an emergency stay, a pause on Monday's sealed hearing until the judge rules on both of those challenges. What they are trying to achieve, stripped of all the legal language, is procedural erasure. They want the tape gone before anyone hears it. They want it treated as what lawyers call fruit of the poisonous tree, evidence so tainted by how it was obtained that it cannot be used. They are not contesting the contents of the recording on the merits. They're not saying what's on the tape is false or misrepresented. They're saying no one should be allowed to hear it at all. Translation: they don't want that tape played, period. And here is the trap they're caught in. If they fight this loudly and publicly, they elevate Bondi. They turn her into a whistleblower figure. They make her look like a woman who risked everything to tell the truth about powerful people who are now trying to silence her. That image is enormously damaging. But if they stay quiet and let the tape slide into evidence uncontested, it becomes the centerpiece of Monday's hearing and shapes everything that happens next in this case. Lose-lose. And they know it. Here's what I want you to understand about Pam Bondi's position, because this is not a panicked last-minute decision. This was choreographed. 12 days ago, 12 days before this week's eruption, she filed a formal immunity application with the special counsel's office. Paperwork like that doesn't get assembled overnight. It takes weeks of preparation, document review, legal strategy. She had this package built in advance. She calculated exactly when to deliver it. She waited for the right moment, and then she moved, filing her immunity application, securing protected status, and delivering the most damaging evidence she had before anyone could block her. This was not reactive. This was controlled escalation. She locked herself into legal protection while simultaneously handing prosecutors the most powerful piece of evidence in her possession. And she did it before Trump's team could go to court to stop her. Former Watergate prosecutor Nick Ackerman made an observation this afternoon that is worth sitting with. He said that when prosecutors use cooperating witnesses who are former cabinet-level officials, it usually means the case is already built. The prosecutors already know what's on that tape. Bondi isn't there to reveal something unknown, she's there to put it on the record officially, under oath, in a sealed proceeding. The special counsel knows exactly what they have. Now they need someone to swear to it in court. That is the stage this case has reached. And then there is Melania. At 3:44 this afternoon, her independently retained attorney, David Wallstone, hired 6 weeks ago, filed a statement that changed the geometry of this entire proceeding. Wallstone asserts that his client never consented to the recording, never authorized its release, and is asserting spousal privilege on her own behalf as a third-party actor in this proceeding. Not as a defendant, not as a cooperating witness, as an independent person with her own constitutional rights, who is refusing to be treated as a mere extension of her husband's legal strategy. Now unpack what that filing actually does to the legal landscape. It confirms the tape exists. It confirms Melania knows about it. Any possible argument that the recording was fabricated or invented by Bondi's team just evaporated because the First Lady's own attorney is now arguing about its admissibility. You don't fight to suppress something that doesn't exist. It also creates legal and strategic distance between Melania and Trump's defense. Her lawyers are not Trump's lawyers. Her filing is not Trump's filing. She is, through this action, signaling that she has her own interests, her own privacy rights, and her own legal standing that are separate from and not subordinate to anyone else's strategy in this case. Think about what that means personally. Think about what that means legally. The president's own wife has hired independent counsel and filed her own legal position that does not align with her husband's defense. That is a rupture. It may be a measured, lawyerly rupture, framed in procedural language and privilege claims, but it is a rupture nonetheless. I want to put this in historical context because this kind of internal fracture inside a presidential administration has happened before, and what happened after it is instructive. Think back to 1973. John Dean was White House counsel to Richard Nixon. He was, by any measure, the ultimate loyal insider. He knew everything. He was present for everything. And when investigators started closing in, Nixon's team did exactly what Trump's team is doing now. They tried to paint Dean as the lone rogue actor, the one unstable person who had gone off script, whose credibility couldn't be trusted. It didn't work, because Dean didn't just testify. He brought documentation, not mere words, but records. Memos, contemporaneous notes, evidence that could be independently verified. And once that documentation entered the legal record, Nixon's defense posture became nearly impossible to sustain. Nixon resigned 14 months after Dean began cooperating. Former Watergate Committee counsel Fred Thompson once said that the moment a loyalist flips and brings documentation, not just words, but actual records, the entire defense of an administration collapses under its own weight. We are at that moment right now. Bondi is not just saying she remembers a conversation, she is delivering an audio recording, 11 minutes of a private dinner at Mar-a-Lago, logged permanently into the federal evidence system. And that recording does not disappear no matter what the judge rules on Sunday. It exists. It's in the system. It will feed into future proceedings regardless of what happens to Monday's hearing. If history rhymes here, and it has a tendency to rhyme, Bondi's submission shapes the indictment, the privilege motions fail, Monday's hearing proceeds, and the obstruction case against Donald Trump hardens over the next 3 to 6 months. So where does the timeline stand tonight? Let me lay out exactly what is coming. Tomorrow morning at 10 o'clock, 19 hours from now, the Senate Judiciary Committee holds an emergency closed-door session specifically about Bondi's cooperation agreement. That session carries significant political weight, even if it has no direct bearing on the legal proceedings. Expect fireworks, expect Jim Jordan. Expect accusations of prosecutorial misconduct, political betrayal, deep state operatives, all of it. It will be loud, but the courthouse doesn't care about loud. Sunday at 4 in the afternoon, 67 hours from now, Melania's attorneys must file their supplemental briefing on her independent legal standing. That document could be a game changer, depending on one specific detail. If her attorneys argue she had no knowledge the recording was being made, that introduces a Fourth Amendment dimension, the right against unreasonable search and surveillance that could complicate Bondi's entire submission. But if her filing challenges only the release of the recording and not the recording's existence, the suppression effort weakens considerably. Sunday at 6 in the evening, 70 hours from now, Judge Hernandez issues his ruling on all competing privilege motions. That ruling determines everything that follows. Monday, the sealed hearing either proceeds or gets postponed, and whatever testimony is given in that hearing becomes a permanent sealed record that feeds directly into the indictment timeline. Legal analysts are describing three realistic outcomes. The tape is admitted in full, the hearing moves forward, Bondi testifies under oath, or the judge partially suppresses portions while admitting others, allowing the hearing to happen in limited form but still getting Bondi on the record. Or he temporarily suppresses everything, forcing the special counsel to appeal immediately to the circuit court, pushing the timeline 2 to 4 weeks. Former federal judge and constitutional scholar Lawrence Tribe made a point this afternoon worth noting. Spousal privilege has never successfully covered statements made to third parties in a group setting. The dinner at Mar-a-Lago was not a private two-person conversation. Other people were present. That matters enormously for how this privilege claim holds up. And even Jonathan Turley, who has been skeptical of earlier moves in this case, acknowledged that privilege arguments face a very high bar when third parties were in the room. Step back from the legal mechanics for a moment, because what happened today goes beyond one tape, one hearing, one ruling. Before this morning, most people operated on the assumption that cabinet-level officials kept sensitive materials inside the executive branch unless they were formally subpoenaed. That was the informal norm. That was the understanding of how power and confidentiality worked at the highest levels of the American government. Pam Bondi just demonstrated that assumption is wrong. A former attorney general retained materials she had lawful access to through her official duties, secured her own personal immunity agreement with federal prosecutors, and delivered those materials directly to a federal judge, bypassing every institutional safeguard that was supposed to prevent exactly this kind of move. She did it legally. She did it deliberately, and she did it successfully enough that the recording is now permanently in the federal evidence system. The precedent that sets is not small. Every future administration now has to reckon with the reality that the people they appoint to the most powerful positions in government could, if they feel legally threatened enough, become cooperating witnesses against that very administration, using materials gathered through their own official duties, materials no one ever thought would end up in a federal courthouse. Executive privilege has been called an unbreakable shield. Today, that shield took a very concrete, documented, legally recorded hit. The political cost for Pam Bondi personally is enormous. Her standing in Republican circles is gone. Her future in that party is almost certainly finished. But she has clearly decided that her own legal protection and her place in the historical record is worth more than any of that. And Donald Trump is now forced to stand in front of a federal judge and argue that the woman he personally chose to run the entire United States Justice Department cannot be trusted with the materials she lawfully gathered while doing her job. I'll be right here the moment anything changes. The moment a filing drops from Melania's team, the moment Trump makes a public statement, the moment Judge Hernandez issues that Sunday evening ruling that determines whether Monday's hearing becomes the most consequential moment in this investigation or whether it gets pushed into the appellate courts. And that is where the ripple effects begin to move far beyond the courtroom. Because what looks like a single evidentiary dispute is actually a stress test of multiple systems at once: legal, institutional, political, and personal. Start with the legal layer again. Spousal privilege, executive privilege, immunity agreements. Each of those doctrines exists for a reason. Each has boundaries. Each has exceptions. And what happened here forced all three into the same frame. That is rare. Usually, these doctrines operate separately. Different cases, different facts, different timelines. Here, they intersect. And when legal doctrines intersect, the outcome is not just about who wins. It is about how the boundaries between them are clarified or redrawn. Because if a court ultimately accepts that statements made in a group setting fall outside spousal privilege, that is not new in theory, but it becomes newly relevant in practice, at the highest level, in a case everyone is watching. That is how precedent evolves, not only through new rules, through high-profile applications of existing ones. Then there is the immunity layer. That is where the shift becomes more structural. Immunity agreements are not unusual. They are a tool. Prosecutors use them to obtain information that might otherwise remain hidden. But the profile of the cooperating witness matters. A former attorney general is not a typical cooperating witness. That changes perception. Inside government, inside future administrations. inside the decision-making process of anyone who holds sensitive information, because it introduces a new calculation, not theoretical, demonstrated. If legal risk rises high enough, cooperation becomes an option, even at the highest levels. That does not mean it will happen frequently, but it means it can happen. And once something moves from impossible to possible, behavior adjusts, quietly, but significantly. Then there is the institutional layer, the informal norm described in that section. Sensitive materials stay within the executive branch, unless compelled, unless formally requested. That norm was never written into statute. It was maintained through expectation, through culture, through mutual understanding. And norms are powerful until they are broken. Once broken, they do not simply disappear. They weaken. They become negotiable. That is the real shift. Not that one person acted, that the expectation of non-action is no longer guaranteed. That changes how information is handled, how access is granted, how records are kept, because institutions adapt to new risks. If the risk of internal disclosure increases, controls often tighten. Information may be compartmentalized more aggressively. Access may be limited more narrowly. Documentation may become more cautious. That is the feedback loop. One event, followed by systemic adjustment. Then there is the political layer. Because while the legal argument will unfold in filings and rulings, the political interpretation is already moving. Inside one party, the reaction is immediate. Trust is reassessed. Lines are drawn. Loyalty becomes a central theme. And in politics, loyalty is currency. Losing it has consequences. As the section notes, the personal cost for Pam Bondi is likely permanent within that political structure. But political cost is not the only currency. There is also legal exposure, historical legacy, personal risk, and individuals weigh those differently. That is what makes decisions like this difficult to predict. They are not purely political. They are multidimensional. Then there is the courtroom dynamic, because the argument now shifts to credibility. If Trump's team argues that Bondi cannot be trusted with the materials she handled, they are making a claim that cuts in multiple directions. On one hand, it challenges the reliability of the evidence. On the other, it raises questions about the original appointment, about judgment, about selection. Because if the person chosen to lead the Justice Department is later characterized as unreliable, that characterization reflects backward as well as forward. That is the tension. And courts are aware of it. Not politically, structurally, because credibility arguments are weighed carefully, especially when they involve high-level officials. Then there is the timing. Sunday ruling, Monday hearing. That compression matters, because it limits the ability of either side to fully reframe the narrative before the next stage begins. It keeps the focus on the immediate question. Admissibility, scope, impact, and rapid timelines increase pressure on legal teams, on messaging, on decision-making. That is when mistakes can happen, or when clarity can emerge. Then step back even further. Look at the broader arc. A recording enters the evidence system. A privilege argument is tested. An immunity agreement is revealed. A norm is challenged. A political rupture occurs. A legal battle accelerates. Each of those steps connects, and each one extends beyond this case, because future officials will watch this. Future administrations will study it. Future lawyers will cite it. Not necessarily as precedent in the narrow sense, but as a case study of what is possible, of what can happen when legal risk intersects with access to sensitive material. That is the lasting effect. Then there is the phrase, executive privilege has been called an unbreakable shield. That framing matters, because shields are not supposed to be tested successfully. They are supposed to hold. But in reality, most legal protections are not absolute. They are conditional. They depend on context, on facts, on interpretation. True. And when a shield takes a hit, as described, the question becomes, was it pierced, or did it absorb the impact? That is what the court will determine. Not in abstract terms, in specific application. Then there is the human layer, often overlooked. Decisions like this are not made in a vacuum. They are made under pressure, legal pressure, personal pressure, reputational pressure. And when those pressures converge, individuals make choices that can reshape institutions. That is what happened here. One decision, with multiple consequences. And those consequences are still unfolding. Finally, return to the central point. This is not just about one tape, not just about one hearing, not just about one ruling. It is about the boundaries of power. who holds it, how it is exercised, and what happens when those boundaries are tested from within. That is the question now moving forward, through the courts, through the political system, through the institutions that will adjust in response. And the answer will not come all at once. It will come in pieces, in filings, in rulings, in reactions, in the quiet changes that follow high-profile moments like this. That is how systems evolve, not in a single decision, in the accumulation of responses to moments that challenge their assumptions. And this is one of those moments, still unfolding, still being defined, and still shaping what comes next. And there is one more layer that tends to surface only after the initial shock fades, second-order effects. Because the immediate focus is always on the headline moment. The tape, the privilege claim, the immunity agreement, the courtroom clash. But the deeper consequences often appear in how behavior changes afterward, quietly, across the system. Start with advisors and senior officials. From this point forward, every conversation that includes sensitive material carries a new calculation. Who is in the room? What is being said? How is it being recorded? Because the assumption that internal conversations remain internal has been weakened, not eliminated, but weakened. And when assumptions weaken, caution increases. That affects candor. It affects how freely people speak, how directly they challenge each other, how much detail they are willing to share in mixed settings. That has implications for decision-making quality, because the best decisions often come from unfiltered internal debate. And if that debate becomes more guarded, something is lost. Then there is the legal profession itself. Attorneys advising public officials will adjust. They will emphasize documentation practices. They will warn about exposure in group settings. They will outline the risks of relying on informal privilege assumptions. That advice will shape behavior long before any future case reaches a courtroom, because prevention is easier than defense. Then there is the media environment. Moments like this change how stories are pursued. If it becomes clear that high-level insiders can become sources through legal cooperation, investigative efforts intensify. Reporters ask different questions, they look for different patterns, they follow different leads. That does not guarantee more disclosures, but it changes the landscape of possibility. And possibility is enough to shift attention. Then there is the political culture. Trust inside administrations has always been conditional, but now it becomes more explicitly transactional. Not in a cynical sense, in a risk-aware sense. Who has access? Who has exposure? Who has potential legal vulnerability? Those questions move closer to the center, not publicly, internally, and internal dynamics shape outcomes more than public statements ever do. Then there is the long-term institutional memory. Events like this get studied, not just in law schools, inside government training, inside transition teams, inside advisory briefings for incoming officials. What happened in that case? What were the vulnerabilities? How do we avoid repeating that? That is how one moment becomes part of institutional knowledge. And institutional knowledge shapes future behavior, often more than formal rules. Finally, there is the broader public perception. People watching from outside may not track every legal nuance, but they understand signals. They understand when something that never happens suddenly happens. They understand when a system behaves differently than expected, and that understanding influences confidence. Confidence in institutions, confidence in leadership, confidence in how power is exercised. That is the intangible impact, harder to measure, but deeply important, because systems ultimately rely on public confidence to function smoothly. So yes, the immediate question is what the court will do next, what the ruling will be, what the hearing will produce. But the larger question is already unfolding. How this moment reshapes behavior across law, across government, across politics, across perception. That is the longer arc, and it is already in motion. Whether anyone in that courtroom intended it or not, this story is not slowing down. It is accelerating with every single hour, and we will find out exactly how fast,